One of the figures that has been most used over the years to obtain papers in Spain is social integration, and it is precisely one of the figures that has been most affected by the entry into force of the new immigration law or the new immigration regulations. In this video, I will tell you about those changes and explain what the new social integration consists of, which will start to apply indefinitely from the upcoming May 20th, and it is possible even if an application is made. If a previous application was made and by May 20th the immigration office has not yet resolved it, it is possible to request that this new social integration be applied under the conditions of the new regulations. So here we go. It is no secret that among all the types of integration, the one through which most people obtained residency and work permits in Spain was social integration, specifically through the job offer route. Let's remember that what is currently required for social integration, this provision will be in effect until May 19th, 2025. That is, applications submitted up to that date, May 19th, 2025, will be processed with what I am going to explain now, and under the conditions I am going to explain now, which have been in effect for many years. Basically, social integration required you to have been in Spain for 3 years and to prove it. Normally, the main proof for this is the historical registration certificate, where there couldn't be gaps of more than 120 days, and well, alternatively, other means of proof such as medical appointments, preferably from administrative entities, money transfers, invoices, etc. Those 3 years, plus having family ties with children, parents, or a partner with legal residence in Spain, or presenting a social integration or social roots report and being able to prove economic means in some way, which could be with a job contract offer, which was the most commonly used method, with a business plan as if you were going to start a company and become self-employed. If you presented economic means with a job contract offer, then the authorization they gave you, obviously, after evaluating that your employer was solvent and that all conditions were met, it was a work authorization solely for employment. If you present a business plan as if you are going to be self-employed, then the authorization they give you is for self-employment. Additionally, you could also do it if you had first-degree relatives living with you and they were willing to provide a letter stating that they support you and have the financial means to sustain you, and that would be another option, yes, or with your own financial resources, which are basically your savings, an amount of 600 euros per month for 12 months, usually around 7,200 euros. In these last two cases, that is, when you neither present a business project nor a job contract offer, you are not authorized to work. They only give you a residence authorization. This, however, does come with advantages, such as being able to stay peacefully, enter and exit Spain, and it counts towards nationality, but it did not allow you to work. Broadly speaking, those were or are the requirements of the current settlement process. But I speak in the past tense because this is already being phased out. This figure has less than 2 months left in the Spanish landscape, the Spanish regulations, and after that it will completely disappear, leaving only the new social settlement process, which I will now explain. The first major change is that the job contract requirement is removed from the social settlement process and is given an independent status. I had already mentioned that it was the most commonly used scenario, the current social settlement, precisely because of that entity. Due to its superior status compared to other scenarios, a special category has been created. Social settlement has been emancipated and is now called socio-labor settlement, forming an individual category. Its requirements have also been reduced regarding the contract and the income that must be earned. It is no longer 40 hours. In some cases, the current social settlement was 30 hours, but it remained there. Now the current requirement is 20 hours in all cases, and one can earn up to half of the monthly minimum. With the current social settlement, that was not the case. Even if you had fewer hours than the maximum legal workday allowed by law per month, you still had to earn at least the monthly salary. Additionally, it brings an important advantage. It allows you to work both as an employee and as a self-employed individual. You are presenting your contract, and we are talking about socio-labor settlement as a significant aside, because this is no longer social settlement, but it is to show you how this scenario has evolved, what social settlement, which consisted of the offer of a job deal, has become. And it brings that huge advantage that now, even if you are proving your financial means with a job contract offer, it will also allow you to work as a freelancer if, for any reason, you have to leave that job. Then you will also be able to engage in economic activity as a freelancer. So there we have it. The first scenario, which was the most powerful one, the social settlement, which is about the offer of a job deal, is out. That is no longer social settlement. That work will be for socio-labor settlement. Then we have the scenario of proving financial means with a business project. This remains, it basically stays unchanged. You need to have a viable business project which must be validated by a freelancers association. If the Arbos economic activity requires a special qualification, then you must have it. If a license is needed, you must have it. If an accredited degree is required, then you must have it. And in all cases, financing is needed, which will vary, depending on the type of business. Similarly, at this point, this is still social settlement. But now, an important advantage is added in the sense that even if you are proving financial means only with a business project, it will also allow you to work as an employee. So if for any reason your project doesn't work, or if it does work but you still want to combine it with a job or a contract for someone else as an employee, you will be able to do so. The scenario where a first-degree relative, who must be parents, children, or a partner living with you, is financially responsible for you and is obviously in a legal situation in Spain, is also maintained. In this case, the advantage for them is double because you are not proving financial means in the form of developing an economic activity that you have to carry out, like working or being self-employed, but rather simply the financial means of a relative, yet you will still be allowed to work both as an employee and self-employed, something that the current regulation does not have, but the new century allows, which is a huge advantage. Regarding the issue of proving financial means with your own money, with your own financial resources, there is a great doubt about this because the literal wording of the new regulation, the new immigration regulation, does not include that possibility. It simply states that the financial means must come from family members, and if you don't have family members, then you should request a report on integration efforts, but it leaves in limbo in that case where the financial means can come from, or not in limbo. It would simply be limited then to coming from the business project, which is indeed considered, but they do not include anything that suggests they can be your own financial means. Understand this as savings, your savings of 7,200 euros as can currently be done, so that it can also be done the same way with the new regulation. We believe that this will be rectified, a clarifying note will be issued, instructions will be provided stating that in cases where you do not have family members, since the regulation allows you to request a report on integration efforts, your financial means, which can be your own in that case, should be evaluated there, and they will have to be your own because it makes no sense to allow access to social routes simply with the integration effort report without proving financial means. If that is allowed, then social labor routes would not make sense, formative routes would not make sense, and the other cases would not make sense. Of social routes, because all of them require at least 2 years and proof of something else, and in practice this would only require you to have 2 years, request the integration effort report and not have to have financial means, and you could access it. Then no one would use the other options. Everyone would go for this one that only requires 2 years in Spain, request the integration effort report, and that's it. You get your social routes without financial means and family just for being in Spain for 2 years, and well, it won't work like that. It doesn't make sense. Therefore, a clarifying note should be issued, an instruction stating that in the case where you do not have family members, you must request the integration effort report. And in that case, the financial means can come from you, solely from you, through savings. The fact that they can come from a business project is already stipulated in the law, that's how it will be, but that they come from you is not clear. It's not clear, but we trust that it has to be clarified because it's logical and, well, it's common sense. That's how things stand. In summary, the new social routes regulation essentially removes the main assumption of the current social routes, the one most used, which was related to the contract issue, and makes it independent, an independent figure called socio-labor routes. And as for the other assumptions, it maintains them, whether it's with a business project, with the financial means of a first-degree relative of yours who is a legal resident, or with the matter of your own savings, at least 7,200 euros, those assumptions are maintained. And besides, it gives them an important advantage, which is that in all cases you will be able to reside and work both as an employee and self-employed, something that the current regulation does not allow. Oops, I was about to finish the video. I almost forgot one of the main benefits of the new social integration, which is that the time requirement is reduced from 3 years to just 2 years, like all the integration processes that require time, which will now be only 2 years. That is another important advantage. A 33.33% reduction in the time that was previously required. 1 less year that you will have to be in Spain in an irregular status, so it's an important advantage as well. As you can see, there are significant changes in social integration, rights are being expanded, and that is something to celebrate, and you should be ready to benefit from it. Remember that the new regulation comes into effect on May 20th, 2025, but since the immigration offices usually take much longer than 2 months to process a case, which is exactly the time remaining until May 20th, there are applications that we even assess whether it is worthwhile to submit them now and simply request that the new regulation be applied when May 20th arrives, and in this way we save time. What's the worst that could happen? Well, that a miracle happens and they resolve it in less than 2 months. In that case, well, nothing, you simply submit it again and that's it. But we consider that what can be gained, which is time for our clients, and we understand that the paperwork is expedited by a week, 2 weeks, a month, is important time. And well, we are taking all actions to expedite these resolutions, even if it means more work for us. If you have doubts, remember, in the pinned comment you have a link. There you can schedule a consultation with me or a member of my team, and we will outline, based on your personal situation, the best path towards your legal residency and the stance towards your nationality, or if you already have legal residency, the best path directly to your nationality. Most of these consultations are free, so take advantage. Additionally, we have a satisfaction guarantee according to which if you do not obtain your legal residency, if you do not obtain your nationality, you do not pay us a cent. It applies under terms and conditions. I will explain it to you in the consultation, or a member of my team will, but generally it works like that. Remember, you can follow us on Instagram at Olegal in Hispano Official, where we post content that's a bit more educational, more dynamic, with more gossip and fun, so you can check us out there. Thank you for your like, for your comment. Share this with anyone you think it might help, and especially thank you for subscribing. Here you'll have a video to watch, either here or here. I'm sure it will be of interest to you, and don't forget, for anything in the world, for God's sake, to subscribe. It's the most important thing. See you next time. Goodbye.